for pronouncement of judgments. Criminal Appeal 295 of 2018.
In view of the above aforesaid discussion and the materials available on record, we are of the view that there is no scope for interference with the impugned judgment. Appeal is accordingly dismissed. We record our appreciation rendered by
Criminal Appeal 97 of 2023, along with Criminal Appeal 0 91 2022.
In both the appeals, the accused appellants are acquitted and
Deeply applied.
set at liberty if not required by the, if not required in any other cases. And we also, legal aid counsel was just Mr. A. Somwa, and we put on record his appropriation of available assistance. But
I'm deeply obliged.
both the appeals are allowed. Group and mind. No worries.
My lord, I beg to mention item number 2.
Yes,
Can it be on some other day, my lord? Today I will be out of station in the second half.
you're for the respondent.
I am for the respondent.
Other side?
Yeah.
When do you want? 2 weeks.
Any day, your lordship.
2 weeks.
Sir.
On a prayer made by Sri B.M. Chaudhary, learned counsel for the respondent number 2. 2
Here are 4 respondents.
for the private respondents. List after 2 weeks.
I am obliged.
Yes,
With the consent of the object. I
Yes.
just to mention item number 12.
well, yes.
In the hearing,
Yes, what is your prayer?
next week, I'm not fully prepared.
Okay. Madam?
Sir.
On a prayer made by Sri A. Tiwari, learned amicus curiae, appearing for the appellant, matter is adjourned to be listed after 2 weeks.
Deeply obliged, Lord.
Come prepared next week.
Yes, sir.
Amicus should not take time.
I'm sorry for that. May I beg to mention on IM alert for listing on 25th, my lord. Next month.
25th, okay. I for
I have for it's for bail, my lord. Please pay in the power.
fresh matter, fresh application.
No, my lord.
I is pending.
Yes.
Notice has been issued.
Yes, my lord. Already opposite party has appeared, my lord.
Okay,
Record has
okay.
obliged.
Monday.
May I please, the Lord? Lordship, I beg to mention item number 7.
Hmm.
In this case, by the impugned judgment, Lordship, 3 person was convicted.
Hmm.
Lordship, one preferred appeal and another Lordship preferred appeal very recently. Yesterday, case was
Yes,
listed
it came up
before this
yesterday, my lord.
honorable court.
Okay.
And then the delay was for 900 days. So Lordship, at first delay petition is put on and then it will come for hearing. Lordship may taken up matter,
I
this
did not
two
make
matter.
This is-
Another also filed by the
Next second.
This has already been admitted. You said that there are other appeals in which delays are yet to be condoned.
It came up yesterday.
Okay.
Lordship granted me time to file objection. Dibyo Kanti Paul Elias Tutan versus State of Assamana.
We do not know
On-
whether we'll condone the delay or not.
Yes.
Lordship, but there is a sufficient ground, Lordship,
You are not the, are you the counsel there?
Lord,
You are the counsel in that case?
in that case.
Salute.
Okay. Sri L.R. Muzumdar, learned counsel
Criminal Appeal
for the
of-
appellant has submitted. that there is another appeal arising out of the same judgment.
Lordship, IA criminal number 1078.
Just a minute, which however has been filed beyond the prescribed period of limitation. And prescribed and accordingly, an IA has been filed. Full stop. Para. He submits that in that view of the, he accordingly prays for an adjournment of this matter. Para. List after 4 weeks.
Lordship, IM number
We are
1078.
not saying anything. IA is yet to be allowed. At this stage, tagging will not be proper.
Right.
This is the stage of hearing, that is the stage even
Right.
for admission.
Obliged.
Okay.
Remember 18 something.
8 is connected. Yes,
Lordship,
Yes,
Yes,
connected.
yes, Lordship.
yes, what about 8? We cannot pass orders in isolation. Both matters are tagged. Where is Mr. Bakshi? Mr. Mazumdar, you have to, you could have
Lord.
informed Mr. Bakshi, but have you, wait for a while, wait for your turn. We'll
Lord.
pass these or retain the order, but not in his presence. Okay.
Yeah, please, Lord. I have based on one case, my lord. We will instead of 26.
Which matter, what matter?
Is a ready for hearing. My
Criminal appeal.
lord.
Matter of which year?
It is 20.
20. Okay, it'll come up for orders, we'll fix for hearing.
Yeah.
By mention memo, it will not come for hearing. Give it for orders on Monday. We'll fix for hearing. Paper book prepared?
Yes.
Okay.
May I please, your lord, what I beg to mention for listing of a criminal appeal for hearing column on 28, my lord.
Hearing it will not come by a mention memo. You make it for orders, we'll fix it for hearing.
Must be good.
Appeal of which year?
2022.
Okay, we'll have it for hearing. Paper book prepared?
Yes.
Okay, have it for orders. Okay.
Obliged, my
Lord, a similar pair, Lord. It was last posted on 18/8/2022, Lord. Thereafter not
Matter of
listed.
which year?
2022, Lord.
Paper book prepared?
Prepared,
Okay,
Lord.
Monday for orders.
Lord. DPO.
Mr. Gogoi?
At 6 plus.
Yes.
I am seeking for accommodation for today. Next week at
You're for the appellant.
Appeal.
Other side informed.
Okay, other side.
There are private respondents.
Fine.
There are private respondents. You have not informed. Have you informed? You have
No.
to inform them. Inform them, come, we'll adjourn the matter.
No.
Okay.
Last, they're not there, but
But at least you have to, then we have to wait for your, the matter to be called upon. We cannot assume that they have not appeared.
Item 1.
May I please, your lord, here, my lord, POSCO matter, my lord, the service is complete. They've appeared for the respondent number 2, my lord.
Mr.
The I-
Imtiaz, you're for whom? R2.
Yes, my. Yeah, my lord, the
I is for what?
I is for bail, my lord, but the objections have not been filed, so.
You'd like to file objection?
Yes, my.
And madam?
Lord.
Filed already?
Not filed, not
Not
filed.
Okay.
Not-
On the
My
prayer,
lord, if I
of-
may, my lord, a copy of the IA may be served to us. We have not.
Yes, sir.
uh, Miss A. Begum, learned APP, as well as Sri G. Imtiaz, learned counsel for the respondent number 2, has submitted, have submitted that copy of the IA has not been furnished to them. Para. Sri Mahajan, learned counsel for the applicant undertakes to serve the copies during the course of the day.
Yes.
Para. On the prayer made by the learned counsel for the respondents, opposite parties, matter is adjourned by 4 weeks to enable filing of objection.
But if, let it be positively filed because,
You have not given copies, how will you file?
say, essentially same, my lord, judgment only with annexed in the IM.
But still then, give the copy.
Can it be a shorter 3 weeks?
3 weeks, can you file it in 3 weeks?
Yes.
3 weeks, madam? Okay, 3 weeks.
DPO.
Obliged, my lord. File your-
Item numbers 3 to 5.
वही क्या था केस की? Yes, what is this?
My lord. Last occasion, lordship made some queries, lordship. To that regard, lordship, I have prepared a note regarding the top of all the sections, lordship. So we paused on that last occasion, lordship, on compliance of section 52A. Before arriving for making any decision on compliance of 52A, lordship, we have to look some more sections along with this section, lordship.
Mr. Kyle, you have a copy of this?
I'm giving lord. Nice. Yes. Yes. Lordship, first of all, lordship, kindly have a look at section 36. Lordship, got it.
Yes.
Section 36 is for constitution of special courts, lordship. And then section 36A, offense tribal by special means. All the offense under this act shall be tribal by the special courts.
Hmm.
That is the rank of the session judge rank, lordship.
Hmm.
So then thereafter, lordship, lordship kindly come to chapter 5 of this act. That is start from section 41.
Hmm.
This is regarding the procedure. This chapter belongs to procedure. I have mentioned in my note, lordship. So it starts from 41, 42. This is the power of the officer will seize the article by giving the authority and issuing the warrant, and thereafter search and seizure by whom, 42, and then 43 seizure regarding public place. Then it's 44 also power of entry, search, seizure, arrest in offenses relating to cocaine, opium, and cannabis. So thereafter all the sections are there. Then lordship come to section 52. So here, the heading is also disposal of person arrested and article seized. We need to read this, Lordship. Heading is like Lordship, section 52A, same. So here in subsection 1, any officer arresting a person under section 41, 42, 43 or section 44 shall, as soon as may be, inform him of the grounds of such arrest. Subsection 2, every person arrested and article seized under warrant issued under subsection 1 of section 41 shall be forwarded without unnecessary delay to the magistrate by whom the warrant was issued. 3, every person arrested and article seized under subsection 2 of section 41, 42 and 43 or section 44 shall be forwarded without unnecessary delay to A, the officer in charge of the nearest police station, or the officer empowered under section 53. 4, the authority or officer to whom any person or article is forwarded under subsection 2 or subsection 3 shall with all convenient dispatch take such measure as may be necessary for the disposal according to law of such person or article. This section is directory. It is also directory, and the section 57, 55, 57 is also directory. But directory section must have to follow scrupulously because punishment is very stringent under this act. That is why, Lordship, if 52 is there, then 52A, disposal of seized narcotic drugs and psychotropic substances. Lordship made a query that this is regarding the disposal of the, at the time of disposal of the contraband. Now, Lordship, kindly come to this first one. May I read, Lordship? Once again, the central government may, having regard to the hazardous nature, vulnerability of to theft, substitutions, constraint of proper storage space, or any other relevant consideration in respect of any narcotic, drug, psychotropic substances, controlled substances, or conveyances by notification in the official gazette specify such drugs, psychotropic substances, controlled substances, or conveyance, or class of narcotic drugs, class of psychotropic substances, class of controlled substances, or conveyances, which shall, as soon as, just after that, maybe after their seizure, be disposed of by such officer and in such manner as that government may from time to time determine after following the procedure hereinafter specified. So thereafter subsection 2. Here direction is that as per 52 subsection 3, Lordship, just after arrest as per section 41, 42, 43 and 44, then the duty entrusted upon the arresting officer to produce the contraband, seized contraband and accused before the officer in charge or the officer empowered under section 53. The officer in charge and who is the empowered officer under section 53, his duty entrusted here in 52A. There was subsection 1, then just after seizure. Then second procedure, Lordship, where any narcotic substance, drugs, psychotropic substances, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred to in subsection 1 shall prepare an inventory of narcotic, drugs, psychotropic substances, controlled substances, or conveyances containing such detail relating to the description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic, drug, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs, psychotropic substances, controlled substances, or conveyances in any proceeding under this act and make an application to any magistrate for the purpose of A, certifying the correctness of the inventory so prepared, or taking in presence of such magistrate photograph such drugs, substances, or conveyances, and certifying such photograph as true, or C, allowing to draw representative sample of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. Where an application is made under subsection 2, the magistrate shall as soon as may be allow the application. 4, notwithstanding anything contained in Indian Evidence Act or the Code of Criminal Procedure, every code trying an offense under this act shall treat the inventory, the photographs of narcotic drugs and psychotropic substances, controlled substances, or conveyances, and any list of sample drawn under subsection 2 and certified by magistrate as primary evidence in respect of such offense. So this is after taking the charge as per section 55. Section 55, police to take charge of article seized and delivered. This will come into play after this. After 52, Lordship, articles and the seized article and the accused produced before the officer as per section 53 or officer instead. Then it is the duty of the officer who received all the contrabands and the parcel, he take the responsibility as per section 55. An officer in charge of police station shall take charge of and keep in safe custody pending the orders of magistrate all the articles seized under this act within the local area of that police station and which may be delivered to him, and shall allow any officer who may accompany such articles to the police station or who may be deputed for the purpose to affix his seal to such articles or to take samples of and from them, and all samples so taken shall also be sealed with a seal of the officer in charge of the police station. If any contraband seized and sealed on the spot, it is not enough. Again, the person who received this, he has to put his seal, own seal upon that, and that thing, Lordship, as per 52 subsection 2, must have to produce before the magistrate for the certification. And the presence of magistrate is because all the, as per section 36A to C, Lordship, the power entrusted upon the special judge. Now, sir, Lordship, in this case, the if 36A, offences triable by special court. All the trials of this cases of such nature, Lordship, under this act, triable by the special judge who is the rank of session judge or additional session judge. So, Lordship, intervention of the magistrate is not there during this period. If once case placed before the magistrate, then intervention of the magistrate is not there, Lordship, because this is why it is in the initial stage. First, just after that, Lordship, produce the accused before or the seized contraband before the magistrate. Magistrate will verify whether this is correct or not, where whatever seized or in inventory prepared regarding the seized contraband, and then thereafter the samples in presence of the magistrate is required. During this period, after completion of that procedure, Lordship, the all the matters will forward to the special judge, Lordship. And thereafter, after receiving by the special judge will take the cognizance of the case. Thereafter, there is no requirements of the presence of magistrate. Then, if they want to dispose the material, then in that case, at the time of dispose, Lordship, the direction will be there, and then accordingly, if they want to dispose it of, then the presence of magistrate at the time of disposal, Lordship, there are some guidelines provided under the notification, Lordship. So that notice must have to go to the accused person. This is regarding the guideline, Lordship. So in our case, Lordship, recently our High Court decided by His Lordship, the Lordship query was that if holder contravenes produced before the court, then whether requirements of 52A is required or not. So in that judgment, His Lordship has decided that at the time, in that case, at the time of producing the accused and the contraband, they have filed an inventory, an application also. But that was seen by the magistrate in the order sheet, it was reflected. There is difference between seen and certified. So that difference has been made in that judgment, Lordship. And in our case also, there was no application at all under section 52A. One inventory report is there, but there is no application at all. And this document also, exhibit 33, seen by the magistrate, that is there. So this was not certified. If it is not certified, Apex Court at time and again decided that if not certified by the magistrate, then that cannot be considered as a primary evidence during the trial. But because magistrate, if certifies, then the authenticity of the contraband, whatever seized by the seizing officer, that will certify by the magistrate. That is why only then this will be the authentified by the court. That in our case, this is not there. We have made the question to that regard in the trial court. Officer stated that inventory was prepared. Kindly look into the inventory, Lordship, for a moment. Inventory at exhibit 33 is number 12. Page 220. Original. Page 220 seen by the magistrate, Lordship. Huh? Sorry, 221, Lordship, because there are two inventories. So that is why 221 is the inventory, 220 is the FSL, relating to the FSL, Lordship. In original also it is seen. It is there, Lordship. Okay. In the original also it is written as seen. And I have gone through the holder record, Lordship, and order sheet dated 8/5/16, Lordship. It is written by the officer, magistrate, Lordship. I'm on hold. He received the test memo and all the things, and he seen it. He has seen that has been written in the order sheet, Lord. So there was no application at all for compliance of section 52A. If in order dated 8/5/16, Lordship, it is written that seen the forwarding report, inspection memo,
This is ordered by the magistrate.
magistrate. It is in the original record, Lordship. 8/5/2016. Seen the I have written in my notes, Lordship. So just for a moment, Lordship, I peruse this thing. seen the forwarding report, inspection memo, arrest memo, and other materials are produced before me. Seized articles along with samples has been produced before me and accordingly seen. I'll flag mark that, Lordship, to the case, Lordship. Then only the samples already prepared and that has been seen, not
He
before.
has
the-
seen the application and he has seen the articles also.
No, there is no application. Seen the forwarding report.
Yes.
Then forwarding report means, Lordship,
Please read the entire word.
seen the prayer of IO Inspector Pawan Vaisane of NCB crime produced is seizure list for scene. The seizure list is seen. Seizure list is there. Original seizure list is kept with this record, case record. Accused so and so are produced by NCB crime under arrest in connection with the above noted case. Seen the forwarding report. Forwarding report means accused forwarded. Inspection memo, arrest memo, and other material are produced before me. Seized article along with the samples have been produced before me and accordingly seen.
He has said that seized articles were produced before him.
Seized on the spot. And also seized articles produced before the seizing officer, not by the officer. It was the duty of PW2.
No, that is a different implication. What is the last line?
Last is seen the Lordship seized article along with the sample.
Seen the seized articles.
Seized article and samples also. Samples already corrected. Then inventory, regarding inventory, court has not mentioned anything, Lordship, any application under inventory. Exactly in that case, there was a application for correction of inventory, but not certified by the magistrate, Lordship. So in our case, that is not there. Only seen. There is difference. The honorable this court, Lordship, our High Court differentiate between certified and seen, Lordship, in para number 8 2022. Lordship, in paragraph number 64
Of?
of the this Lordship, criminal appeal number 67, Lordship, I have placed. Oh, Diana Silva in that.
আছে নেকি এইটো ইয়াতে দিছিল নেকি সেইদিনা নে ঘূৰাই লৈছিল নেকি
এটা আছে ৰেকৰ্ড আছে
ৰেকৰ্ড আছে ৰেকৰ্ড কৰা না ঘূৰাই লৈছিল নেকি
paragraph number 64
ঘূৰাই লৈছিল ঠিক আছে Page?
Page number 69, Lordship.
Yes, 64.
64. Reverting back to the case in hand, the prosecution has contended that an inventory of goods seized, Exhibit 2, was prepared following the due procedure, and the said inventory of goods seized, Exhibit 2, was duly seen by the magistrate. As such, there was due compliance of the procedure prescribed in Clause A of subsection 2 of Section 52A of NDPS Act. From a look at the inventory of goods seized Exhibit as Exhibit 2, it is noticed that the same was marked as seen by the learned Chief Judicial Magistrate Kamrup Guwahati on 6/12/2014. there is distinction between something seen and something certified. Ordinarily seen means perceiving something with the eyes, discerning something visually. On the other hand, if one certifies something, it means he has arrested or confirmed in a formal statement. Certificate means an official document attesting a fact. The certificate is associated with a more responsible act. So this has been differentiated, Lordship, seen and certificate. In our case, seen magistrate seen the inventory placed by and not in a formal way, Lordship, as per this. In application, they must have to write these things, Lordship, regarding 52A. And with an application, Lordship, for certifying correctness of inventory, taking of presence of such magistrate photographs, this must have to, ABC must have to write in the application. Then only the officer will certify after verifying all the things, Lordship. Sometimes we found in some cases, officer prepared inventory along with the nowadays, Lordship, prepared inventory and all the contrabands produced before the magistrate. And magistrate again weighed it and then found that there is difference between the weight and the after that sample also. That is the list of sample that is, and all the weight must have to mention in the magistrate order sheet. That is the reason behind this, to authenticate that whether really any charge and seizure was made or not at the place of occurrence by the officer. Magistrate presence is required for this purpose only, to that regard, Lordship, to authenticate the search and seizure. So in this case, Lordship, subsequently, if we, Lordship, go through this 65 and 66 till, Lordship, 70, the similar case, Lordship, in of present with the present case, Lordship. 65. May I read this, Lordship?
No, suppose, let us assume a case. There was a checkpoint or something, and without any tip-off, in a random checking, something has been detected and found. Then the question of seizure, immediate seizure had arisen. The bringing the magistrate at that point of time may not be possible. Well, how do you deal with that?
No, that is well, Lordship. At the in checking point, if seizure made by the police was there and some person found there, then it is the duty of the officer after seizure. He must
After, if you are insisting that the seizing has to be done in the presence of the magistrate.
That is why section 52 is there, Lordship. 52 is there. If person gets there, then it is the duty of the officer collect all the things, and thereafter seizure should be made there, and he hand over these things to the
Nearest police station.
or the officer empowered under section 53. Thereafter, all the procedures start.
So in that circumstances, absence of the magistrate will
But
not
that
vitiate.
time magistrate is not required.
It will not vitiate. It will not vitiate.
No, that not vitiate, but that time magistrate presence is not required. Thereafter, magistrate presence is required when it is received by the.
But if you are acceding to that thing, then by that time seizure has already been done.
Already been done. That is why authentication is required that, at that time after seizure, Lordship. Whether really it is done, whether the weight is accurate or not, whether the samples collected that is accurate or not.
Mr. Kyle, what do you say on this? In a given situation of this kind, where seizure has been done on a random thing, maybe in some odd hours in the night, then it was not possible to bring, or maybe, so, but it's already been seized. What is the meaning of seizure? How do you seize some articles?
Seizure can be made by the.
How? What is the meaning? You take it into custody, the article, that is the seizure. And you.
Yes, definitely after covering the goods, they will have to seize, and they have to deposit it for the godown.
And you follow 52.
52 and the other 6.
52 and bring it to the nearest order of by the time seizure has already been done.
Then lordship was,
So where is the requirement of presence of magistrate during the seizure?
that is not
During
required.
the seizure, not
That
during the-
situation, magistrate presence is
So if in a situation, you can differentiate whether a magistrate's presence, it will be subjective in nature. So how do you objectively, how do you give the safeguard to an accused? If an accused insists that yes, seizure has to be done in presence of a magistrate, and you make out a case that it was not possible,
then lordship,
then
the
where is the thin line of distinction?
consent of the accused is to be taken before, that if he is, shot by in body, then, he has to be informed. Written of the, written, it to be
That
given.
will also have many loose ends, lacuna. You write he has consented.
No, lordship, that is to be proved during the trial. And in this case also that has been done. There was a search in their bag and their body search was there. For body search was made, they informed them, they gave it their written consent.
And in the examination,
Examination lordship, that the document has been proved. That
no,
in
no,
the-
no, whether the consent part,
That has been proved.
Denied.
They have not denied.
We have denied. Denied the- we have made, we have crossed the witness on length on that point. That has been denied.
did you lay the foundation of denial? Because see, you are the accused, you are not really required to come up as a witness. But you have to make out, build up a foundation, a platform in the, when you get a chance to cross-examine. Did you put such a question?
Yes,
You had put
yes, Lord.
that
We put the questions and we denied
regarding
also.
the permission and no permission was taken. We had not,
Yes.
did not
In
consent.
presence of magistrate, we are not on section 52. That is why lordship section 52 will come into existence only after body search.
My lord, only one thing, like 52, my lord, 2 yellow, again, kindly see, my lord. 2, my 52A2. Only question comes, my lord, after the seizure,
52?
not during the seizure, my lord. 52A subclause 2, my lord.
Mm.
Once again, your worship has, she has read many times, my lord. Where any narcotic drugs control so and so has been seized and forwarded to the officer in charge of the nearest police station,
Mm.
or to the officer empowered under section 53. The officer referred to in subsection 1 shall prepare an inventory of such so and so narcotic drugs, etc., my lord, etc., or the packing of which they are packed, country of origin on other particulars as the officer referred to so and so may consider the relevant to the identity of the narcotic drugs control station also in any proceeding under this act. And so up to prior to this end, my lord, seizure part, my lord. After seizure, make an application to any magistrate for the purpose. So it
No,
comes
no,
second.
no, the first part is not
Yes,
seizure. The first
exactly.
part is preparation of inventory.
Preparation assessment
It's
after seizure, my
already,
lord.
it has already been seized.
Seized, right.
Please
Only,
read- please
your
read-
worship was saying, but during the seizure, not.
Please read again. When any narcotics so and so
When any
has
narcotic
been seized, the seizing is over
seized
and forwarded.
and forward. So after seizure, they prepare something inventory. Thereafter, make an application to the magistrate for the purpose. What is the purpose? Certifying the correctness of the inventory so prepared. That is the duty of magistrate, my lord. Or taking the presence of such magistrate photograph substance and certifying such photographs as true, or allowing to draw representative samples of such drugs or substance in the presence of such magistrate and certifying the correctness of any of these samples so drawn. Sometimes, I suppose 10 bottles seized. From 1 bottle, my lord, everything was sent to the FSL. So magistrate to see, my lord, whether from each bottle it was taken on. So these things are to be, my lord, for the purpose of magistrate, my lord. So magistrate question comes subjectively. Now here our case is whether they made an application or not. Whether first there is inventory or not. Thereafter whether they made an application or not. If there is application, then sub 3 will come. Subclause 3 will come. Where an application is made under subsection 2, the magistrate shall as soon as may be allow the application. So first it will satisfy them about correctness, about truthness, about this thing, about sample, sending of sample from the different bottles, different, etc. Then he will allow, thereafter the rest thing will come back. So here, this is the case, our case is based on this point. That whether inventory was made, whether application was made to the magistrate, whether magistrate only hears what they have seen. Whether seen is equivalent to certifying that PMI.
Yeah, that is
So
already.
there
been
you're
decided.
also very much aware, my lord, you're also aware.
That
So
has-
this is our case, whole case, this is our case. If that was done, I have no case.
But again, we come back to the same question.
Yes.
52A is the basis of 52A is for what do you do before you dispose of the seized materials?
Oh, so dispose it.
Before you, what do you do before, because it starts with disposal of seized.
Before
narcotic drugs.
disposal, two will have to be followed.
Yes.
Surplus two
Now
is
this contraband was not disposed
Oh, that was as per that, but I find it is not yet, I think.
because it was produced in the code.
Produced in the court.
P1 to P7.
No, whether produced or not, that is also not clear, my lord.
No, it was exhibited.
Application, assuming. Right.
Exhibited.
Exhibit is there, my lord. But whether it actually primary, original things, but main question with application certifying, three things have to be satisfied. Two, my lord. Even for disposal, of course, two it to be complied with first matter. Preceded. It preceded by this matter to procedure. Then that will come disposal, question disposal will come.
No, it's the other way around. If you want to dispose of, you have to abide by two. If you don't want to dispose of.
No,
whether
that is
two
not
will
my
come at
question,
all.
matter whether I want or not, matter. Question is, why disposal come? Sometimes being matter, there is no accommodation. Then
No,
maybe,
that is that if you read the first 52A
Right.
one,
yeah,
the different circumstances have been given.
no, central government may,
Yes, may,
Uh,
having regard
shall,
to,
yes,
may, having regard to
yes, may having regard to the hazardous nature, vulnerability of theft,
substitution,
substitution, constraint of proper storage space, or any other relevant consideration in respect of any narcotic drug, narcotic substance, controlled substance, or conveyance by notification in the official gazette, specify such narcotic drug, substance, controlled substance, conveyance, or class of narcotic drugs, class of controlled substance, which shall, as soon as may be very important matter, which shall as soon as may be after their seizure, after the seizure be disposed of
that is,
by such officer. Be disposed by such officer. Now, before the disposal, two will have to be followed.
yes,
This is the
before
question.
the disposal.
Before the disposal.
Now, if you have not disposed, then
No, then suppose if it's not disposed by not 51, 55.
52 and 55.
By the 55 you're possible fine.
Following
Hmm.
52.
Hmm.
Before following
Yes,
52,
Mm,
52 and 55.
yes. But the 55 just have a my lord. An officer in charge of a police station. Or 52. And my lord, I am sorry, my lord. Again, let us come to 52 matter. He's insisting, I think she is right matter. 52. Disposal of persons arrested and Article 6.
you have read this. But
That
still then-
already you all
then
lost
Still
it.
then, if you want to read, still read.
Yes, that is it.
If you want to read, please do again. Let us
Yeah,
again.
then 55. Mane ready 52 man. Police to take charge of the article seized and delivered. So
Yes.
once produced, they'll to take charge.
No, please read.
Yes.
It's before.
Any officer in charge of a police station shall take charge of and keep in safe custody
Pending the orders of the
pending the
magistrate.
orders of the magistrate.
It has not even gone to the magistrate. Before
Yes.
it goes to the magistrate, you take
Madam,
charge.
Yes, before taking to the magistrate. Ma'am.
Yes.
That I also already put this question, my magistrate. All articles seized under this act within the local area of that police station and which may be delivered to him and shall allow any officer who may accompany such articles to the police station or who may be deputed for the purpose to affix his seal to such articles or to take samples of and from them, and all samples so taken shall also be sealed with the seal of the officer in charge of the police station. That is during that period, my lord, with the seal it is to be retained. That is. Yes. Then 55, no. Yeah. Yes. Now, madam, 52 is a surplus 3 A and B, madam. No. 52 A. Yeah. Officer in charge of the Oh, yes. Yes. So that is during that period, madam, it is to be kept with the under seal and cover with the magistrate. Thereafter, these things will come, madam. Magistrate place before the applicant, they will make an application, it will place to magistrate will certify about all these things. After that it comes. And after handing over that point. During that initial period, it is kept with him. Till it is put before the magistrate. Thereafter, my lord, this thing 52 that. So this is the basic thing, madam, in this case, madam. The rest part we have denied, madam, the cost, as he said, madam, that is denied. I am handing over to her, madam.
My lord, once again, the judgment of this honorable court lordship kindly go through the para number 65, page number 69. Para 65. Yes. 65, page number 69.
Yes, please, from the.
From the evidence or material on record, it has not emerged that on any date after 6/12/2014, the respondent customs authorities had applied before the magistrate for certifying the correctness of the inventory of goods seized, exhibit 2, so prepared after search, recovery and seizure of the contraband substance, cannabis, ganja, weighing so and so. It is a fact that respondent customs authorities had during the trial produced and exhibited physical evidence in the form of 29 HDPE packages seized on 5/12/2014 as material exhibit 1 to exhibit 29. From production of material exhibit 1 to material exhibit 29 during the trial, it is discernible that the prosecution did not dispose of seized contraband cannabis ganja till that stage of the trial following the procedure laid down in section 52(1) of the NDPS Act and Standing Order number 1/89. Or one of the reasons for non-disposal of the seized contraband cannabis can be prima facie made relatable to non-compliance of the procedure laid down in clause A and clause B and clause C of section 52(2) of the NDPS Act as without following the procedure laid down therein. Disposal of seized contraband substance is not permissible under subsection 1 of section 52 of NDPS Act. Then Lordship 66, from the prayer made in the application dated 6/12/2014, filed before the court of learned Chief Judicial Magistrate, Kamrup Metro, Guwahati, it is clearly evident that there was no prayer made to the learned magistrate to certify the correctness of inventory of goods.
Just a minute, man. 71 section. Primary evidence. You can discuss. You retain something which should be primary evidence. Mm.
certificates would be.
Necessary.
It is suppose 52 disposal was not done. Then we have the primary evidence if they can prove it through other season witnesses. This is the material. which was
Proceeds.
seized. Then the question is, in the case where contraband is seized, 53, 52A, and 52 regarding disposal was not followed. In whether it will affect the prosecution case. How it will affect. In case of common here to Russell, here to 52A is not been followed. The mandatory provision is not followed. Into 71 year to primary evidence. Because when primary evidence has been produced, the court has option to rely on not to rely.
No, that's a different, that's a different, that's a different option. There's a
We
different
insist
question
that you
altogether.
have to produce primary evidence under 52. A4 is the only primary evidence.
এটাতো একদম হেৰি হৈ যাব, ব্যতিক্ৰম হৈ যাব না। প্ৰাইমেৰী এভিডেন্স মানে কি আচল বস্তুখিনি, এইটোতো এটা safeguard হে দিছিলে।
Believe that
Mm.
thing which is.
That's a different matter. You may still have a case
Now,
to say.
if the questions when may implementing authorities will start not following technique. Following intent by way of whether he has to follow the case of empty Caesar. Then if it is not followed,
না, 52A language-টা একটু কোৱা নাই না। এই circumstances disposal may be necessary. Disposal কৰা, এতিয়া কি কৰিব লাগিব তুমি?
নহয়। So.
But এই conditionত if you want to dispose of all, the central government may regard to the
Because of these circumstances, disposal is necessary. People for for to be implementing authority that hazardous oil in Jaga Sinai. Because of these reasons, statute has itself provided that you have to dispose it of as soon as it is seized, which shall as soon as maybe after seizure be disposed. So therefore, there is a mandate of the statute disposal.
কিন্তু সেই মোহনলালততো সেইটো কৈছিলে ষ্টেট বিলাকৰ পৰা ষ্টৰেজৰ ফেচিলিটি আছে না, সেইটো পৰ্যন্ত ৰিপৰ্ট কৰিছিলে সুপ্ৰিম কোৰ্টে। The central government may, having regard to the census by notification that specifies such
How to interpret this? Which shall as soon as.
Whether this 52A is mandatory or directory, that's a different question. They কৰিব লাগে, dispose নকৰিব লাগে। এতিয়া এটা কেছত কৰা নাই। সেইটো that will not affect the merits of the case.
That they have to submit. How it affects your. ইহঁতে এটা কৰিব পাৰে।
That's still open for them. That is still open for them.
Merely saying that people therefore 71 and the presumption of judgmental with the 71. People are pushing
Mr. Chaudhary, one thing is slightly matter of concern, because see 52A again even for the sake of repetition, it lays down something which is in contemplation of a disposal of the seized articles. There are many circumstances for which it is not desirable to keep. If you dispose of, then what do you retain? For the prosecution tomorrow to bring a case against the accused. So you have to maintain something and to give full safeguard to the accused certification, attestation, everything by the magistrate is required. And number 4, subsection 4 says that notwithstanding anything which is an exception to the normal law. Normal law requires primary evidence to be produced. Here, since the articles are disposed of, is nothing. You cannot produce tomorrow.
Okay.
So
Once it disposed, yes.
the inventories, which has been the photographs, the list of samples which has been certified by magistrate, will be treated as primary evidence. That is 4. Now, will this exception mean that this is only the thing which is to be retained, which is to be regarded as primary evidence, and not the materials which were seized? See, matter is a different matter. It will be a different question. If you raise a issue that the materials which was produced in the court is not the materials which was seized from us, that you can prove it through that the seizure witness was not there, he has not certified, or he has not said that this was the article, this seal is not there. That's a different argument which is available to you. Another argument which may be available to you is that the samples which were sent for examination was not taken from this lot which is produced in the court. But can you say that this 52A4, which talks about primary evidence, will only be confined to the inventory list of samples, photographs certified by the magistrate, and it will disregard the primary evidence in original? We
No,
don't
it
think
will
so.
not
Why
disregard.
not? Because this is an exception.
Oh, exception is my notwithstanding anything, again, I am reading one.
Yes.
In the evidence act, it's so and so,
Yes.
evidence about 62, 63.
Yes, yes.
Section 62,
Yes.
63, evidence act one. Code is so and so, every court trying an offense under this act shall treat the inventory, the photographs, drugs, psychotic substance, controlled substance, conveyance, and any list of sample drawn and certified by a magistrate as primary evidence in respect of such offense.
See, this is an exception
So-
carved out.
So,
Whatever is stated in the evidence act regarding primary act evidence, secondary evidence, notwithstanding that, this inventory, this list of samples, these photographs, which have been certified by the magistrate,
so which
will
are
be
certified as a
magistrate
magistrate.
will be taken as primary evidence.
Exactly, my lord. Now, is certified by the magistrate.
Yes.
Our question on that,
Now,
Yes.
before you go to the question,
my lord.
if the original seized goods itself are produced as primary evidence, where is the question of having this as primary evidence?
My lord, when primary evidence will come, my lord. When this will be treated to be only certified, produced,
No, that-
certified,
No,
then
no,
my, it will
no, no,
constitute a primary
Mr.
evidence,
Chaudhary, you have not followed the question.
my lord.
We have understood what you are saying, that this list which was not certified by the magistrate. So this is not to be treated as a primary evidence.
Right.
52A4 has been violated.
Oh.
We
No, it will not constitute a primary
for
evidence.
the time being. But here is a case where the goods itself was produced before the in the trial. So why do you need to fall back upon this kind of primary
My
evidence?
lord, if foundation is there, if foundation is that, I mean, they will not follow, then how trial, my lord? Trial court ought to have gone to that aspect, my lord. Ought to have, once that is fulfilled, that
No,
is complied.
there would have been no problem in accepting a submission if the primary evidence was destroyed, disposed of. The
My,
primary evidence was there, the entire.
certainly, my lord, if primary evidence, there, certainly, my lord, that.
That is there.
That, no, my lord, in my humble, my lord, opinion, my lord, when it comes, my lord, again, if you
No,
read,
no,
my lord.
we are not on the law. On the facts, we have seen that
So,
primary
on-
evidence was produced.
So on the fact, when it was produced, my lord, during trial,
Yes,
during trial, it was
that is
produced.
proved.
Now, my lord, if whether that's the same thing, which has not been certified, suddenly they have come and they have produced something related to trial, can it be treated to be primary
That's a
evidence?
different submission.
My lord?
That is a different submission.
No, my lord, this
The
is the.
primary evidence in the form of the seized articles
Yeah,
were not the actually articles which were seized. That's a different submission. It's open for you
Yeah.
to urge. We'll
Yeah.
consider that.
yeah.
But that has got nothing to do with this certification. This is only certification of the inventory, of the list of samples, of the photographs.
My lord, here the whole, if you read the whole sentence, my lord, one primary, it will be treated to be primary evidence, my lord. When that's a certificate, during the trial, it is another aspect, my lord. Here, what they are saying, yes, in Mohanlal there, Mongilal is there, my lord. This has been explained, and Mongilal also it has been explained. It is there, my lord. My question is, my lord, when notwithstanding, my lord, shall treat the inventory, photographs, narcotic drugs, so and so, control so and so, and any list of sample drawn under so and so, and certified by the magistrate as primary evidence. So primary evidence will be construed only when these are satisfied.
Secondary. It has qualified only that to that extent. The secondary evidence will be primary. But primary always remains primary.
You cannot substitute for it.
Yeah,
Because
52A for example, in G, secondary,
kindly come to page 21 of the paper book.
Page 21.
21.
My two paper books, one is
No, no, ঠিক আছে, ঠিক আছে।
correct
Correct
one.
one.
Yeah.
It is
Page
21,
221. Naki.
220.
21.
Only.
21.
Yes,
This is
I have first line.
this is a part of the evidence.
Materially exhibited.
Evidence, isn't it?
Yes,
The evidence starts at page
yes,
the PW3, I think.
yes.
You come to page 21. I have seized the articles. Have you read?
Yes, yes.
Material exhibit 1 is the dark brown color sticky material marked P1, which contains 10.08 kilogram.
Hmm.
This is the seized goods.
Articles, yes.
This is not about the samples or the list of inventory. The earlier page, if you turn to the earlier page, exhibit 33, inventory under 52A NDPS Act. These are my signature. Your arguments are based on this, that this inventory is not being certified by a magistrate, it is seen by a magistrate. We'll accept that. We'll accept that. Let us assume we accept that.
Hmm.
But what about the next page?
This material exhibit.
Exhibit 1, Exhibit 2, Material Exhibit 2, Material Exhibit 3.
Lordship, it will, this will be clarified, this has been clarified by Honorable Apex Court in Mohanlal Lordship. In
And-
Mohanlal Lordship, it start from paragraph number 11, last line. Page 407. Mohanlal to disconnect. Mohanlal to
Page?
Page 407.
Yes.
407, last line of paragraph number 11. Having said that, we must mention that we are in the proceedings concerned with the following three issues only for the present: seizure and sampling of narcotic drugs and psychotropic substances, their storages and their destruction. So seizure and sampling. We need not to read this because last occasion we have read that part, Lordship. Lordship, kindly come to page number 409 and paragraph number 16, 17 and 18. 17 is more clear regarding Lordship's query.
17.
17.
Page?
Page number 409, paragraph number 16, 17 and 18 is very essential, Lordship.
Yes.
16 is subclause 3 of section 52A requires that magistrate shall as soon as may be allow the application. This implies that no sooner the seizure is effected and a contraband forwarded to the officer in charge of the police station or the officer empowered, the officer concerned in law duty bound to approach the magistrate for the purpose mentioned above, including grant of permission to draw representative sample in his presence, which samples will then be enlisted, and the correctness of list of samples so drawn certified by the magistrate. In other words, the process of drawing of sample has to be in the presence and under the supervision of magistrate, and the entire exercise has to be certified by him to be correct. The question of drawing of samples at the time of seizure, which more often than not takes place in absence of magistrate, does not in the above scheme of the thing arise. This is so especially when, according to section 52A(4) of the Act, samples drawn and certified by the magistrate in compliance with subsection 2 and 3 of the section 52A above constitute primary evidence for the purpose of the trial. Suffice it to say that there is no provision in the Act that mandates taking of samples at the time of seizure. That is perhaps why this is regarding other state compliance. Be that as it may be conflict between the statutory provisions governing taking of samples and standing order issued by the central government, that such a conflict shall have to be resolved in favor of the statute on first principle of interpretation, but continuance of the statutory notification in its present form is bound to create confusion in the minds of authorities concerned instead of helping them in discharging of their duties. The central government would therefore do well and re-examine the matter. And after that, Lordship, 22 notification has been come out, and it is specifically in paragraph number 17 clear that if not just after the seizure, if not followed, the procedure maintained in both 52(1) to 52(2)(3), Lordship, then and 4, then this will not constitute as a primary evidence if produced before the trial court. That has been discussed in our High Court judgment. Lordship pointed out that materially exhibit before the court and materially exhibit before the court. In the cross also, it is mentioned that though it was in the godown, but in some material exhibits, there is no signature, godown in charge, and entry number of godown. This has been mentioned, Lord.
Where in our case?
In our case,
Where page?
page number 25. In cross. Material exhibit in the first two paragraphs, Lord.
Yes.
Material exhibit 3, 5, and 7, there is no signature or any seal of the godown in charge of NCB and godown entry number
Where, page 21?
25.
25.
Yes, paragraph first and second, Lord.
25.
Yes.
Yes.
In material exhibit 3, 5, and 7, there is no signature or any seal of the godown in charge of NCB, and godown entry number is also not mentioned in material exhibit 3, 5, and 7. In material exhibit 8 to 15, there is no signature and seal of godown in charge, nor there is mention of godown entry number. So, for the authenticity of all the things, Lordship, they first, as per section 52, they deposited the contravention sample to the officer in charge PW2. PW2, she has stated she received. Then thereafter, again it produced before the court, and court again handed over to them. Then they produced before the court during the trial and materially exhibited before the court. But thing is that there is no signature of the godown in charge, whether it was in the godown or something else. Lordship, the same thing produced before the court, same thing must have to produce before the court. If there would have any signature or certificate of the magistrate, then only it would have constituted as primary evidence. Lordship. There is discrepancies regarding the seals and all the signature of the godown in charge. Where they have kept, they can manipulate these things. Lordship. That is why compliance of section 52 A 2, 3, and 4. 4 only come into existence after following the procedure prescribed in subsection 2 of 52A. So that has not been followed in our case. And on the length also, it was cross this witness lordship regarding non-followance of the compliance of this section 52A lordship in page number 26.
Hmm.
27.
Which-
Paragraph number 1, 2, 4.
In
Fourth
pa-
paragraph. In
Panchnama.
Panchnama, exhibit 19, I mentioned the color of the seas contravents as of dark brown color. I did not mention in exhibit 33 in the inventory mode of packing of the contravents, marking or any specific mark in the packet. I did not file any application before the magistrate for certifying correctness of the inventory so prepared by me. In
No,
process.
that part you have clear. We are not in the inventory part.
But in paragraph number 17 of Mohanlal,
This, once you have said that the inventory was not certified,
Hmm.
no point that inventory was prepared, not prepared, we have.
but
let us-
that
let us
is why
assume- Let us assume we have accepted that part.
Lordship,
We are only on the part of the primary evidence.
produced before the court. That is why. So Lordship query is regard to that, Lordship. But that is not authenticated. Original one or not, whether that was placed before the court, magistrate, and before and same
No,
contraband.
that has to come out from the materials. That cannot be an argument unless you have sufficient materials to say that those produced were not the authentic materials. Where is the materials?
That is why Lordship compliance of 52A is required, which has been cleared in paragraph number 17 of the.
Madam, you're diverging from the question. The moment you said that the materials which are produced, whether it was authentic or not, so are some materials that it was not authentic. That put the question that P2 is not the articles which you have seized from us.
That Lordship, that is why Lordship in our latest case 2024.
Don't go to the case, show in the facts.
Facts is there.
Are there any materials in the facts
Yes, Lordship.
to
that-
even suggest that
Mat-
the materials P1 to P7 were not the seized articles?
Lordship, because of not giving any suggestion, the whole case.
That is the foundation, madam.
But
You are the
if
defense.
they have not followed the mandatory provision, then Lordship, then.
You're again falling back to something which we are not even presently concerned. We'll accept. Let us presume we accept. 52A, inventory, everything, we accept. We are on the accept of primary evidence. Normally, what is the Evidence Act? That the seized material have to be produced. This is the primary evidence. Here an exception has been carved. That if you dispose of the seized material, what will happen? Will the prosecution be left helpless? They cannot. They maintain a sample, they list, they prepare an inventory, but all those have to be certified by the magistrate, which shall form as a primary evidence. Now that part has not been done, but the articles which were seized are still retained by the authorities and those were produced.
Those were produced, but Lordship, see the condition of this Lordship, the in cross of this witness.
That we have appreciated. Some seals were not there,
Yes, Lordship.
some signatures were not there.
Yes. In almost all the packets, Lordship, he has not mentioned that the seal of the.
How many packets were seized?
Lordship, total seven number of packets.
The irregularity or whatever illegality in the manner of producing those is confining to which numbers of exhibits, material exhibits? 3, 5, and 7 only.
Other parts also they have not mentioned in their material exhibit.
No. Your question, cross-examination.
Cross-examination. 3, 5, 7
Yes.
and 8 to 15. 8 to 15.
Before that, you come to page 21. How it was,
1, 2, 3.
material, see, please read 21, material exhibit 1.
Material exhibit is 1 to 7.
On material exhibit 1, P1.
P1.
So and so, it contains the signature of the judicial magistrate on 8/5/2016. That is the chief. We will come to the cross later on. Exhibit 2 is another P2 contains the signature of the magistrate. Exhibit 3, P3 contains the signature of the judicial magistrate. So, oh,
Okay.
this, such, is the condition for all the up till P7, Material Exhibit 7,
P7, magistrate,
yes.
P7, but in cross, it is mentioned 357 and 8 to 15. These are not with the, and good, it was kept in Godown and, Godown in charge signature, which is requirement of the section 52 of this act and 55.
What about Material Exhibit 1, 2, 4, 6?
It is not mentioned in their deposition.
They have mentioned-
Deposition, it is not mentioned in their deposition, lordship, in 1, 2, 4, there was a signature of the Godown in charge and it was the seal of the debt was not exhibited. Though question was not there, but
See,
it is
you
not,
have put questions
it
for,
is their case, they have to establish, lordship.
you have put a question for 3, 5 and 7
Yes,
only. At page 25, the first line. What about 1, 2, 4, 6?
but a chief also, it is not mentioned, it is the signature of signature of Godown in charge and the Godown register number. It is mentioned in material exhibit, and that has been exhibited, that signatures. That is not there.
Then you should not have put a question only to 3, 5 and
But
7.
my question, before my question, they have to establish their case, lordship. They have not established, they have not mentioned in their deposition, lordship, this is the signature of good or goodest MR number is mentioned in the material exhibit like that. Because it was in the Godown as per PW2.
See, it was certified by the magistrate. His signature was there.
Certified signature of the judicial magistrate that has been admitted, lordship. It was produced before the magistrate. With the samples, it is produced there as per 8/5/2016. It is seen by the magistrate, but it was kept just after a seizure. One day they kept, one night they kept in the Godown of the NCB, lordship. It is mentioned by PW2. They did not produce the material, Godown register
See,
to certify it.
7-5, the materials were seized. 6-5, the information was received.
On 7/5 night, intervening night, it was kept in the Godown of NCB. It is mentioned by the, it is deposed by the PW2. Godown of register number.
That evidence under 52/4, যেহেতু disclosure. Then they will go chain of custody and to produce from seizure to exhibiting before the court in trial. Chain of custody was properly maintained. Otherwise, we will have to change policy. Change policy. Theoretically, there should not be any gap. Economy 3, 5 and section 55 of the same. Before producing the form magistrate, intervening any character so that the sanctity of Caesar is not questioned. Prosecution then you have to the chain
Or
of
what?
then this is the original request. So madam gave like
Need to question, I was section at page 21. Page 21. Material exhibit number 1 is the draft from so and so as P1. Which contains so and so seized from the position of accused Soraba at a date. It contains the signature of the independent witnesses, 4 accused persons, and the seizing officer. It also contains the signature of the signature on 8-5. 6-5 what information person? 6-5 what? 7-5 what 6 police, 8-5 makes better police.
one cannot wait.
Push, you devote whole body.
That will change.
No.
That madam to show that one cannot transaction to company wholesale, one can register, one can accept office. Delivery because you are added in the certification then register question would have been interview period. Then there is a burden. Anything new question
Review for is a question. Review for is a answer to this. Repeat for the answer. 55 to also available. Intervening custody will be taken dealt with.
you can get that otherwise wanted case over.
Yeah.
Correct.
Given that 55 has to be followed. Because the burden to emergency that we have to do. If we are relying on the primary certification of the person in itself.
May not be fatal. Not be fatal. Your main contention is that 52A has been violated. The endorsement seen by the magistrate cannot amount to certification, and it has been laid down by our court. And once it is violated, there is no primary evidence, and therefore the case was not proved against you. That is your main case.
Main class of the case. And if you want to, so here in this case, Lord, okay. Regarding the last. Here, Lordship found the signature of the independent witnesses in a material activity, whatever produced before the court. But as per order dated 9/2/2018, Lordship, these two witnesses are no point of time examined. And order dated 9/2/2018, return answer with the report that no person in the same name was found at Satgaon, Dolibari area. Since the person could not be traced in the address, his
This
evidence
is order of the learned special court.
is special court. Could not be traced in the address, his evidence could not be recorded. Sufficient time granted to the complainant to prove their case by summoning the witness. a last chance is given to the prosecution to bring all the witnesses, including the charge sheeting officer. So thereafter, though last chance was given to them, thereafter they did not give any effort to bring these independent witnesses before the court. 2 persons.
What will be the effect?
Because authenticity.
No, what is the effect? No, irrespective of that.
Yes.
Independent witness not produced.
Lordship, independent witness not produced, except the independent witness and the seizure witness,
Case
seizing officer.
law.
Case law. Independent. Mohammed Khalid expressly stated, Lordship, latest judgment. No? Khalid. Yes, sir.
AC to develop.
Okay. Is that? Economy.
I think last occasion you had given a copy,
Yeah.
I think. But you had taken it back. Mohammed?
Mohammed Khalid Lordship. But that is Honorable Apex Court has stated that the FSL report is nothing but a waste paper. In that case, Lordship, this has been also. I have highlighted.
Paragraph?
Lord. Form. Hmm. Phone number is it? Lordship, paragraph number 21. Yes. Two independent punch witnesses, Sarif and Mithun Jana, who were associated in the recovery proceeding, were not examined in evidence, and no explanation was given by the prosecution as to why they were not being examined. Services also prepared samples. Testimony of PW5 were not examined in evidence. In addition thereto, the prosecution neither examined any witnesses nor produced any document to satisfy the court regarding the safekeeping of samples right from the time of the seizure till the same reached to the FSL. The official who collected the samples from the police station and carried the same to the FSL was not examined at the trial. From the quoted portion of the evidence seizing officer, it is clear as the daylight that he handed over one of the three samples. This is, we have already read in three samples, then 7 samples came out, but independent witness is not examined in this case also. Our case also, independent witness, though someone is stood and not found that person, why those persons not produced before the court, that explanation has not given. If signature found in the material exhibit, except the PW3, there is nobody to prove the case, Lordship, because he has stated, as per the office order, Lordship will find at page number 156, 10 numbers of uh, 10 numbers of official witnesses associated with PW3. Even after that, those persons' presence he has not exhibited by obtaining their signatures on the documents prepared at the spot and even in the material exhibits. And those signatures, though he has stated independent witness signatures were there, they are not before the court. To prove that, only the signatures of and the signature of the godown in charge is also not there. He has not exhibited those signatures also. PW2 is the godown in charge. He has also not stated that I put my signature over those articles which had handed over to her on that night. For intervening night, she kept it with her till producing before the court first time. Then thereafter again deposited these things to her till producing to the court during the trial.
Yes.
Other persons, except the PWT, there is nobody. That is why there is doubt regarding the authenticity of the seized contraband rights.
But it has been settled, reiterated again and again, it's the quality, not the quantity. Are you doubting the version or the narration deposition of PW3? Have you put questions upon him that he was not there, team was not there? If he is not trustworthy, then your argument would have some force. But if it is trustworthy, his credence could not be shaken in the cross-examination.
It is not the fact that
He's that Vasane, isn't it? Vaisane, Pavan.
Pavan Baisani.
Hmm.
It is not a fact that apprehended accused person so and so and so reached to hotel, and it is not a apprehended accused Mujibur Rahman from ISBT. It is not a fact that so and so were not at the place of occurrence at the time. It is not a fact that so and so were not seized from the possession of accused Mujibur Rahman and Abdul Kalam. Into page 28. In cross lordship, we asked regarding the non-arresting of the person from the place lordship. That question is there in Buddha cross in page number 32.
32.
32. Fourth number paragraph lordship. Then it is not a fact that I did not comply with
Which
that.
were 32, which part?
From the bottom lordship 1, 2, 3. Second paragraph from the bottom.
It is not a fact.
Yes, it is not a fact that accused Swanson Saurabh Khan was picked up in front of the hotel Fortune and on
It is
5.
true.
It
It is true.
it is not a fact.
No, it is true that Saurabh Khan was at Hotel Fortune.
And then it is also not a fact that
Now,
So-
where are you reading?
I'm
Paragraph?
reading in this paragraph now, second paragraph from the bottom.
It is not a fact that there is
Saurabh
no-
Khan was picked up, page number 32,
later on.
later on.
And they are compelled to put in a black scene and converted within subsequent 67. It is not a fact, denied. Then it is true that accused Saurabh Khan was at Hotel Fortune, Walton Bazaar, on 5/5. It is true that Saurabh Khan in his statement stated that he had checked out from the said hotel on 6/5. I did not investigate or inquire.
Then second paragraph, it is not a fact that not possible to carry 2 packets containing 10 kg or more in each polythene. It is not a fact that no contraband was recovered from the possession of accused Saurabh Khan and accused Ram Milan. It is also not a fact that accused Saurabh Khan and accused Ram Milan were not involved in the present case. It is not a fact that both accused persons were picked up on the previous day and thereafter they were so on and accused in the present case. It is not a fact that the present case against accused Saurabh Khan and Ram Milan is manufactured case. It is not a fact that accused persons Saurabh Khan and Ram Milan were not in any way connected or related with the other 2 accused persons involved in this case. It is not a fact that I proceeded this case in a defective way without following the procedure laid down in the NDPS Act and the CRPC. It is not a fact that there were no independent witness of Exhibit 18 search and seizure, it is not a fact that the case is manipulated for the purpose of getting promotion and other from the superior officer. So this is regarding Saurabh Khan Rammilan and also Mojibur Rahman and Abdul Kalam. Page 27.
27.
Yes. It is from the bottom second paragraph. It is not a fact that since the statement were not voluntary, the same was not recorded in presence of independent witness and in presence of any gazetted officer. It is not a fact that our officers gave the draft to the accused persons who were in the custody at that time and compelled them to write according to our draft, while the accused persons themselves wrote their statement 67 and there was no question of read over to the same again to them. It is not a fact that exhibit 16 and 17 are not the consent given by the accused Mojibur Rahman and Abdul Kalam. It is not a fact that I did not comply with the provision of section 50 of NDPS Act before the body search of the accused persons. It is not a fact that I apprehended accused Abdul Kalam from Hotel Ritz Patan Bazaar at 7 p.m. It is not a fact that I apprehended accused Mojibur Rahman from ISBT Guwahati at 6 p.m. It is not a fact that the accused persons Mojibur Rahman and Abdul Kalam were not at the place of occurrence on the date and time of occurrence. It is not a fact that material exhibit 3, 5, 7 are not seized from the position of the accused Mojibur Rahman and Abdul Kalam. It is not a fact that the said two accused persons did not carry any contraband with them and nor we seized any contraband from their position. All the four accused persons appellate denial is that they were not at the place of occurrence.
Your clients are residents of which place?
Two from Manipur, two from Bihar.
And the persons in the truck, they were whom?
They are from Manipur,
And in the Scorpio?
Scorpio from Bihar. In the truck, Abdul Kalam and Mojibur Rahman, and Scorpio, Saurabh Khan and Rammilan. But to that regard also, their truck is not seized. Only the documents. The Scorpio also not seized or produced these things and ownership of the. There is also doubt. We have made question to that regard.
Your defense is that you were staying in a hotel in Paltan Bazaar.
Paltan Bazaar.
And you were picked up from that hotel.
That hotel.
Yes, anything else, madam? You are appearing for whom?
We for all.
How many appeals are there?
Only 3 appeals.
3 appeals.
3 appeals lordship in one.
Just a minute, I think we have made a note.
Yes,
Just
yes, on last occasion note.
Just clarify. Mojibur, okay, Rammilan.
Mojibur,
288.
288, Rammilan and Abdul Kalam in one case, Saurabh Khan in another case. So 3 appeals. And they are inside the jail from the date of arrest. Today is about 8 years. What? 8 years, 6 months, 12 days today.
Yes.
And punishment is
Since
for,
the date of arrest.
since the date of arrest, sir.
Punishment for?
Punishment 20 years. Minimum punishment under this act is under 20C is 10 years. And lordship, without framing of charge under the section lordship, charge is lordship will find 21C and 29. But conviction is under 17C. 21 or anything. 21C, 17C, and sorry, the 17C and 21C, Lord. Without framing of charge, 17C and 21C. Ito gonna pick up 23 po. Huh? Okay. Kumain ko doon eh. Huh? Huh? 51 and 53. Huh? To that present lordship, I would like to place of our High Court judgment. Single custody. Of division bench lordship. It is stated the above learned trial. It has
What about section 222?
to section
222?
22 is regarding lordship
No, 222 of the CRPC.
of yes. Mistake. Una notin mo hindi. Sentences which High Court and sections may pass. Ano?
Even though you're not charged, you can be.
Mo বিচারি পৌঁছে নতুন সবাইকে নতুন
I know something. To do. I'll let you believe.
Then you can 17 of OPM.
মতো
Manufacture process.
You have to do OPM also.
কোন করে
You have to offense.
any person is part with the
Statement.
consisting of several particular combined complete minor.
Okay, anything else? We'll hear Mr. Kyle then.
Regular repair.
First, I want to place page 33 of the paper. Figure 2. Collecting of samples and correct page 33.
Just a minute, please. Thirty-three.
Paper. Third paragraph.
Yes.
Is under invited comma. The learned counsel for the accused person, Saurabh Khan and Ram Milan has submitted prayer for opening the seal packet of contraband in the open court. Then third, the learned counsel for the parties prayer is allowed. Hereafter, Lord. Material exhibit 1 marked as P1 at the time of seizure containing 10.8 kgs of opium is found in the seal condition. The packet is covered with white marking cloth and label pasted over the same, and it was found into properly sealed condition. After opening the packet, it is found that there is a dark brown sticky substance inside packet. Material exhibit number 1 marked as P1. The seized item contains 10.8 kgs has been opened in open court in presence of the accused person and the lawyers of both the sides. After opening the said packet, it is found that there is a dark brown sticky substance inside the packet. First packet was wrapped with brown color sheet and thereafter it was covered with white marking cloth. It was found before opening. It is properly sealed condition and label was pasted rightly. Another packet of this contraband marked as P4 containing 10.12 kgs marked material exhibit 4 has been opened in open court in presence of lawyer, both the sides and accused person. The same was found in properly sealed condition and label was pasted over the covered packet and was opened for accused Ram Milan. After opening the same, it is found that the sticky dark brown colored substance inside the packet, it was also appeared. The packet was firstly wrapped with brown paper and thereafter it was wrapped with white marking cloth. Lordship has seen the purpose of section 52A. The purpose of amending the section will place before a Lordship again. But purpose is that if the sample which has been collected would not be manipulated or changed. Lordship has seen from this paragraph, everything was produced before the court at the request of the accused. Lordship now, Lordship may come to page 20. Already been placed again. I'm again placing exhibit 33. The middle portion of page 20. Page 20. Exhibit 33 is the inventory under section 52A of the NDPS Act, wherein exhibit 33.1 and 33.4 to 33.4 are my signature. On 8.5.
Who is this? My?
It is the line 2.
No, who is this my? My is means who? PW?
PW3.
The seizing officer?
Yes, sir.
Pawan.
Pawan
Desan.
Desan.
Okay.
And below that, on 8/5/2016, I produced the siege opium and morphine and documents and four accused persons to the judicial magistrate, Kamrup M.
And morphine also.
Then Lordship, below that,
Manufactured. Yes, then
Lordship, exhibit 34 is the prayer for judicial custody of the 4 accused persons in connection with NCP crime number so and so, and recovered 54.68 kgs of opium and 2.60 kgs of morphine. Exhibit 34/1 is my signature. I requested prayer requested prayer was made to the CGM Kamrup Guwahati to allow the seized vehicle bearing registration number so as the custodian. Then Lordship, next page. Material has been
These
exhibited.
are the two vehicles, truck and the Scorpio.
Yes, Lord. That is requested prayer made to the end to allow the seized vehicle number so and so as the custodian. Then Lordship, next page, page 21. All material exhibits were produced before the court and which were marked. Lordship, for just example, I am reading one first paragraph.
Just a
have
minute.
Seized. I have seized the articles along with the samples has been produced before the court. Material exhibit 1 is the dark brown color sticky materials marked as P1, which contains 10.8 kgs of opium seized from the possession of the accused Saurabh Khan. It contains the signature of independent witness or accused persons and seizing officer. It is also contains the signature of Judicial Magistrate Kamrup Guwahati on 8/5/2016. All the materials were contain the signature of independent witness as well as the London. Now, Lordship, I want to place there exhibit 33. Exhibit 33 is at page 2 to 21.
2?
2 to 1. Lord. Exhibit 33.
Inventory.
Inventory. But please to see exhibit 33. The case number is written there on right side. Scene
Yes.
the eligible of Judicial Magistrate. Fortunately, please to note the dates. These are very important. 8/5/2016. Reading the NCP crime reference to inventory of the seized affected at the Lokra near entrance gate of the Indira Gandhi Stadium. Inventory of goods seized under section 52A of the NDPS Act as amended for violation of section 8C of the NDPS Act. Then name of the accused has been written. Then next page. Name of the seizing officer is there. Sri Pavan Vaishani. The place and date of seizure. Lokra near entrance of Indira Gandhi Stadium, Karsojai, Guwahati on 7/5/2016. Then signature of independent witness is there, Dineshwar Krishnamurthy and Nilan Rajpur. Then signature of all the accused persons are there. Then next page, page 22-24. Lord. Description of the article says opium packet marked as P1 to P6. The packet 1 P1 to P6 contains deep brown color powder believed to be opium. All packets are packed with plastic bags containing weight and plastic bags as furnished below. Then each packet sees their mark. Then weight, second column is weight with samples, weight without samples, and sample 2 samples of 24 grams each. Take 24 grams. Then column 2, the packet containing packet 7, P7 containing deep brown colored powder believed to be morphine. This packet with seal bag and weight of the plastic and same description is mentioned here. The next page, Lordship, signature of the independent witness is there, and the signature of all the accused persons are taken here. And Lordship, page 2 to 7. Description of the samples is written here.
Just a minute, please.
page 227.
Just a minute.
Sure.
227.
First column serial number, then number of samples, sample of opium, original sample opium, marked S1 to S6. Each samples containing 24 grams in weight. Then duplicate samples marked as D1 to D6. Then sample 2. Original samples of morphine marked as S7. Then duplicate sample of morphine marked as D7. These samples containing 5 grams in weight. Then below the signature of independent witness and signature of all the accused parties. And all other these materials were described, page 229. PAN card, carrier permit, Indian currency, insurance receipt of all the accused has been written here. Then the signature of independent witness and accused person were taken. Then page 231 is also important. The application filed before the learned magistrate. Carried. The Chief Judicial Magistrate Kamrup, pro PI Court Kamrup Kanto, the declared for judicial custody of Saurabh Khan, Mujibur Rahman, Abdul Kalam, and Ramdev. Sir, it is submitted that on basis of information received, NCB Guwahati has seized 54.6 kg of opium and 2.60 kg of morphine on 7/5/2016 from a near entrance gate of Indira Gandhi Stadium, Sarsoja, Guwahati. NCB crime number so and arrested following person. Accused persons along with all seized items and the samples drawn, original and duplicate in sealed conditions are produced before the Honorable CGM of Kanpur, Guwahati. It is therefore requested that Saurabh Khan, Mujibur Rahman, Abdul Kalam, and Ram Vilas is sent to judicial custody for 14 days as the investigation is under process. The prosecution may kindly be allowed time to complete the investigation and file complaint if any. Then prayer was made that the petitioner begged to state that due to hazardous nature of the drug and constraint of the storage space in the office court, it is humbly prayed that your honor will be pleased to admit this petition and further be pleased to pass such order or orders as your honor may deem fit, and all the samples along with the accused person and secretary produced before the learned seat.
This was on 8/5.
This was on 8/5.
Thereafter,
Order was first, my learned friend has pointed out the order for it is
which order?
8/5 passed by the learned.
Where?
This
This
is
is
the
the original record, Lord. I have written in my notes, Lord. 8 paper.
What was the order passed?
It is on 8/5/2000.
Kindly see what was the order passed?
Seen the prayer of the IO,
Hmm.
Pawan Besani of NCB crime, produced seized list or seizure list for scene. The seizure list is seen, original seizure list is kept with this SCR. Accused Sancho as a reward are produced by NCB crime, the arrest in CW, the above noted case. In the forwarding report, inspection memo, arrest memo, and other materials are produced before me. These articles along with samples has been produced before me, accordingly seen.
8/5/6.
On being asked, the accused persons have stated that they will engage legal counsel. Considering the nature of the offense, at least I find the arrest of the accused person justified, as there is no prayer for police custody. Demand of the accused to judicial custody till 2005. the IO has said that there is no available room for keeping the vehicle seized in the extent case. Truck number so in their custody. The IO is directed to coordinate with the local PS as to the possibility of keeping the vehicle in their custody and therefore make a prayer to settle. All the seized materials along with the accused were produced to the magistrate on thanks. The Lordship has seen that the material was seized on 7, was produced on 8, the very next. Lordship, now,
Now, here is one question.
Sure.
At page 231, the application which you have just mentioned.
Sure.
This was made on 8/5, correct?
8/5.
Kindly come to the prayer.
Sure.
At second page, before you go to the prayer, kindly come to the last paragraph at page 231.
There, it is therefore requested that Saurabh Khan, Mujibur Rahman,
First prayer is for judicial custody, correct?
first prayer is the accused persons along with the all
Seized
the
items,
item samples, original, duplicate, in seal
that is
conditions.
not a prayer.
No, that is purely
No,
report
no,
of
first prayer is to send them to judicial custody.
to hazardous nature of the drug,
And second is,
constant.
it appears to be a prayer under 52A.
Yes, sir.
He has said hazardous nature, he has not said anything, go for disposal, but
That is
he has
nothing else.
mentioned this. But the 8/5 order passed by the learned magistrate does not appear to be an order under 52A.
Yes.
He has only simply
He has seen
send-
them, he's seen the materials and
sent them for judicial custody.
and put his signature on the sample as reflected in the evidence of PW.
Who is it negative 8/5? What? A sample thing is available.
He has seen the sample. It is correct, Lordship, it was not drawn before. The samples were not drawn before. Now, Lordship, regarding the purpose of section 52, Lordship, please to come to page 157 onward. Page 157.
150?
So go down receipt number 1. The 4 go down receiver exhibit A.
Yes.
Annexure 1, go down receipt number 1, NCP crime number 4 of 2016. Receipt, paragraph 1, 6, seal packet, marked with white mark cloth, marked as P1, P2, P3, P4, and P6, containing 10.8 kgs, 10.10 kg, 10.7, 10.12, 10.16, 3.8 kg of opium respective. 2.
This Tulika was produced as a witness,
PW2.
Tulika.
Yes.
Okay.
Paragraph 2. One seal packet marked with white marking cloth marked as P7 containing 2.5 kg of morphine. And 3. One seal yellow envelope containing 3 numbers of PAN card, 1 number of permit, and 1 number of insurance premium receipt. 4. One seal yellow envelope containing Indian currency amounting to rupees 17,000. 5. 12 seal yellow envelope marked as S1 to S6, D1 to D6 is containing 24 grams of opium. Then 6. 2 sealed envelope marked as S7 and 8 D7 is containing 5 grams of morphine. All the above items are intact and properly sealed with NCP brass seal number 1 and entered into godown by entry number 28/2016 of godown register. Then facsimile of the seal is print here. Then date, Lordship, please to note the date. It was on 7/5/2016, time 17:45 hours. Then there is a signature of godown chart, Tulika Moran. Was exhibited exhibit type. Next page, page 158.
158.
Yes, sir. Is another godown receipt. What we have seen that description is similar to exhibit 5. All the paragraph 1, 2, 3, 4, 5, 6 with regard to the materials received by the officer received for production in the port. Then let me see below decimal seal, it is there. Then date is 8/5/2016, next date 13:30 hours. This is the signature of the common TW3 who received the
Received for production in port.
port. Is on 8/5. The notice is seen that the granted by state is seen on 8/5. As per the season. And as the order passed by the notified. Then page 159. Again, this is go down receipt number 3. Received after production in the port. Description is similar. Then logic, yes, here decimal seal is not there, but date and time is mentioned. Date 8/5/2026, time hour 19:30 hours. The signature of the godown in chart. Logic, godown receipt number 4. Exhibit 8. Page 160.
Just a minute, please. One 160.
160. Is the godown receipt whereby the samples were received by the teaching officer to send to the receipt.
Then to
Send to the FSA. Receipt. Serial number 1. 6 seal yellow envelope marked as S1 to S6 is containing 24 grams PM. And 2. 1 seal yellow envelope marked as S7 containing 0.5 gram morphine. All the above mentioned items are intact and properly sealed with NCP brass seal number 1 and exit the godown white entry number 28 of 2016 of godown register. Date is 9/5/2016, 10 hours, the signature of Tejiko.
from where do you submitted it? This was for,
It was taken from the godown.
no, it was for the purpose of
Purpose of sample.
scientific examination.
Yes.
From where do you,
No, because it's the sample number 1. But it now, I want to place the receipt. Okay, page 220, exhibit 33. 33 is written twice. There is some discrepancy. Page 220.
what is this?
This is the receipt of Director of Forensic Science. Thereby he received that the letterhead is not there, it is typed by amendment. Book number 85.
Yeah.
No, no. It was verified by the registry secretary. Received parcel packets wooden so. By serial number 7 envelope, exhibit all 7 envelope. Crime number 4 of NCB Guwahati. Deal from Zonal Director NCB Guwahati Zone, site number 20. 7 of opium and morphine dated 9/5/2016 from messenger by registered Toronto on Besani, IO of the case. Dr. Singh, go down to skip number 4, was 65 on Besani. And he has taken all these samples from go down to submit to the forensic. And Lordship is to see the date 9/5/2016. And Lordship, page 219, exhibit 32. Is correlated with go down receipt number 4, page 219.
Yes, what is 219?
219 is the letter written by the officer to the forensic, whereby he deposited the sample, for example. To forensic, to chemical examiner, forensic science laboratory, Kailipada, Guwahati. Name and address of the sitting officer, Narcotic Control Bureau, Guwahati Unit. 1. Sample packet sealed with brass seal number 1 of NCB Guwahati zone. Section 1. Then crime number is written, name of the accused person is written. Number 3. Alleged description of the drug, brown color powder believed to be morphine, and dark brown color sticky material believed to be opium. Weight of the samples and net weight. Then Lordship, P.
Was somebody sleeping in the court?
Lordship, sorry.
Nobody was sleeping in the court, I think. It was an alarm.
It was Lordship, for many hours I was not using for properly. Sorry. And Lordship, serial number 3 is alleged description of drug and weight of purpose of net samples. Sample number S1 to S6 are 24 grams. Each file.
Okay, we'll continue at
Sure.
2 o'clock. Today's second half, maybe some difficulty, we have to rise early in the second half.
I try to complete.
Try to complete.
I may be excused.
Yes,
I may be excused.
yes, yes.
I did informant first.
Yes. Which one? Item number? Who is out of station?
Informant.
Okay. I don't know, 6. On a request made on behalf of the Learned Council for the informant. Yeah, huh? To put him, huh? List after 2 weeks.
My lord, item number 11. I second the phrase step, my lord, for respondent number second time.
Without seeing the records, we cannot be able to, will not be able to pass any orders. Mr. Bakshi, your matter was mentioned by your friend, Mr. Mazumdar. We did not pass orders because your matter is connected. Come at 2 o'clock along with him. We try to pass some orders. You also come at 2 o'clock. We'll see the records. It will record too late with you. Or it will order to put it.